Good morning. Welcome to the March session of the Court of Criminal Appeals, the post St. Patrick's Day hearings. As many of you know, you have 20 minutes on each side. If the appellant wants time for rebuttal, please let us know at the first. On the panel today, to my left, your right, is Jill Barty Ayers from Montgomery County, Clarksville, Tennessee. My right, your left, is Judge Rob Montgomery from Sullivan County, Kingsport, Tennessee. And I'm Robert Holloway from Columbia, Murray County, Tennessee. Anything else? Got it. Any preliminary matters?
No, Your Honor.
All right, call the first case, please.
State of Tennessee versus Mario Albanese.
Good morning.
Good morning.
My name is Catalina Goodwin, and I represent the appellant Mario Albanese. I'd like to reserve 5 minutes of my time for rebuttal. This is an appeal from a sentencing hearing where first-time offender Mario Albanese was granted probation but denied judicial diversion, which was advocated for by the victim's mother and unopposed by the state. Mr. Albanese pleaded guilty to 3 counts of aggravated assault causing extreme emotional distress, based on the undisputed fact that Mr. Albanese, who has autistic tendencies, touched the victim, his daughter's, vaginal area at her request to help her sleep. The victim and her mother have autism.
Let me ask you, because I'm a little
Yes.
bit, the record's a little bit confusing. Do we actually have the underlying facts of what happened for this plea in the record?
In the sentencing hearing transcript, sentencing counsel, Mr. Johnson, who's here with us today, provided a statement of facts that was agreed to by the state. There was not a formal filing that was titled stipulated facts or anything like that.
Yeah, just when I looked at the plea transcript, it was unusual in that there was no, I know this was brought up by information, but there was no factual basis for the plea, and there was some comment that the state would provide that. I just didn't see it in the record.
That's correct. There were some informal discussions about the stipulated facts, but what we're going by here is what was said at the sentencing hearing. But you're right that the state did not submit anything on
But
the
you're saying
record.
that was agreed to and stipulated to by the defendant and the state at that time?
Yes, that's correct. The state said at the sentencing hearing that Mr. Johnson correctly stated the facts here during the sentencing hearing at the onset.
Okay. I didn't read the transcript yet in full, but I just was curious as to, how we even knew what the underlying facts were for the plea.
Yes, Your Honor, and the stipulated facts that you do see at the beginning of the sentencing hearing. So Mr. Johnson goes through the facts, and the state agreed that Mr. Johnson correctly relayed the facts. And here the state also said that the significant mental health issues of the defendant, the victim, and the victim's mother, all the autism that we're seeing here, drove the resolution of this case and was the reason that the state determined it would not be able to prove the essential element of seeking sexual gratification in this case. The parties agreed to 9 years of supervised probation, which would last until Mr. Albanese's children are adults, with special conditions that he continue to support his family financially and not have any direct or unsupervised contact with either of his children, which includes the victim. This is a mental health case, which is how this case is ultimately resolved. But the trial court repeatedly referred back to the dismissed sexual offense that was originally charged during the sentencing hearing. The trial court committed legal and factual errors. The record is sufficient for de novo review, and this court should vacate the trial court's order and place Mr. Albanese on judicial diversion. This is a case where the court should employ de novo review. The standard of review on appeal from a sentencing decision is, of course, abuse of discretion with a presumption of reasonableness if the trial court properly apply the purposes and principles of the Sentencing Act. When, as here, the sentencing decision concerns judicial diversion, the trial court must also weigh and adequately explain all of the Parker electroplating factors.
Which it did certainly go through all of those factors. So tell me how what your position is on why that was not adequate, because as I looked at it, the trial court went through all of the factors.
While the trial court certainly did go through every factor, it's our position that a lot of its explanation was mere lip service, or the trial court admitted confusion over certain factors, and it also considered irrelevant factors, like his prior experience as a prosecutor.
So when you say lip service, do you mean he said it but he didn't mean it?
By lip service, I mean he identified the factor, but one thing that we saw the trial court do again and again was say, we're going to talk about the a certain factor like interest of the accused and interest of the public, and then he repeatedly referred back to general deterrence instead, treating general deterrence as this overarching factor instead of considering the individual factors that the trial court is required to consider under Parker electroplating. Trial courts are statutorily required to make certain findings before imposing sentence. So I'm going to start with the general factors rather than the judicial diversion factors. Here, the trial court was presented with evidence on each of the factors required under TCA 40-35-210B, but it didn't make any sufficient findings regarding the principles of judicial diversion, as opposed to identifying all the factors, the proffered mitigating factors, relevant statistical information, and Mr. Albanese's allocution statement.
Well, some of those things go toward the sentence, and wasn't this already an agreed to 9-year probation sentence with the only issue being diversion?
Yes, it goes to the sentence, but it still has to be considered as a whole before the trial court makes a sentencing decision, and both in accepting probation and when it decided to decline judicial diversion. And all of these factors that we see under 40-35-210B and under State versus Bias are procedural safeguards that are in place that the trial court is supposed to consider before it makes its sentencing decision.
Are you saying the court had not accepted the 9-year agreement on probation before the sentencing hearing? Wasn't that part of the plea?
That was part of, that is correct. That was part of the plea, and I apologize, Your Honor. But whenever it was considering judicial diversion, it still needed to go through all of these steps. These are procedural safeguards. It's a constitutional due process issue. And by failing to go through each of these factors, the trial court committed plain error, plain legal error, which is why de novo review should apply here. I'd like to begin with the denial of the right of allocution. At the close of argument, defense counsel informed the trial court that Mr. Albanese had a planned allocution statement. But after recess, the trial court immediately imposed its sentence, and only after denying judicial diversion did the trial court allow Mr. Albanese to speak on his own behalf. But by that time, Mr. Albanese was on his back foot. He was in a disadvantaged position of asking the trial court to change its mind.
So after the break, did the defendant come in and say, I want to make my allocution, and the trial court denied that?
No, they did. Not immediately after the break, but it was the last thing said before the recess. And whenever the trial court came back on after the short recess, the trial court went right into the judicial diversion decision.
But nobody stopped the trial court and said, remember, Judge, he wanted to make an allocution.
That's true, Your Honor, although I would submit that by raising it at the close of proof that the issue was properly preserved and that he did.
I'm not suggesting it was waived. I'm just, if...
When did the judge get the allocution statement in writing, that they said it would be similar to that? Was that before the break?
There was a letter written by Mr. Albanese that was included with the sentencing filings that he had in advance of the sentencing hearing.
And it was announced at some point of the sentencing hearing that his allocution would be consistent with that written statement. Is that correct?
Yes, it's consistent with, although there's a humanizing element to being face-to-face, as we all, of course, are right now.
Okay.
So the right of allocution is most clearly violated in situations where the trial court imposes unlawful procedures, like placing the defendant under oath or allowing cross-examination, neither of which occurred here. However, the idea underlying those violations, that your right to speak on your own behalf can be impeded by those kind of artificial constraints, can still come to pass in other circumstances. And in State v. Keithley, this court held that if there's any doubt about whether the right of allocution has been violated, the thumb on the scale favors the defendant.
But he did make an allocution.
But not until after sentencing.
But did the trial court say that it had now considered the allocution and what that impact was on the sentencing decision previously announced?
Not clearly. The trial court responded, is that all? After Mr. Albanese gave his allocution statement, and he did not clearly reevaluate all the evidence in light of Mr. Albanese's statement. And Mr. Albanese's allocution statement, just thinking about this from a psychological perspective, he had just heard all these reasons why he doesn't deserve a second chance, doesn't deserve judicial diversion. And then he's now on his back foot and having to talk the court into changing its mind, which is not the spirit of allocution. And that's why allocution is supposed to happen prior to the sentencing decision being raised.
Let me just end the order again. The way
Yes.
I understand it, he was presented a written statement that, and a statement from defense counsel that his allocution would be substantially the same as the written statement. Then the trial court ruled and denied diversion, and then the defendant then said, I want to give an allocution. Is that right?
That's right. They are still different, though. And I would submit that under both 40-35-210-B7, which requires the trial court to consider an allocution statement, not a letter, but the ability to speak on his own behalf in his own statement, that's critical here. And there is that statutory right to allocute that here he didn't get to say his piece prior to imposing sentence. And there are also the constitutional issues that I raised in my brief as well, that Article 1, Section 9 does protect a defendant's right to be heard by himself. And for all of those reasons, his right to allocution was denied, and that is a reason to vacate this sentence and remand it to the trial court. Let's turn now to the bulk of Mr. Albanese's argument, the judicial diversion specific issues. There's no dispute that Mr. Albanese, a first-time offender convicted of aggravated assault, was statutorily eligible for probation and for judicial diversion. For an eligible defendant, the trial court must consider both the broad principles of sentencing alternatives and the individual Parker electroplating factors, which are the same common law factors that we see for probation. For broader principles, judicial diversion is a form of probation that affords certain qualified defendants the opportunity to avoid a permanent criminal record. It's this second chance, as you all are well aware. And in this case, the trial court did not articulate the underlying purpose of judicial diversion. It didn't discuss the second chance and why Mr. Albanese, in this case, was not worthy of it, even though we submit that he was. Here, the trial court only said, after going through the Parker electroplating factors inadequately, but still going through all of them, of course, the trial court just said, this doesn't extend all the way to diversion. It didn't explain why. It didn't talk about the underlying purpose and principles of judicial diversion, about having a second chance, avoiding a felony conviction, and the other issues that we raised below. The trial court abused its discretion by failing to articulate its difference and those principles. As to the individual factors, I'd like to start with physical and mental health. The trial court acknowledged some of the mental health issues in this case, but when it was evaluating the physical and mental health factor, it determined that this was neutral as it pertained to the judicial diversion factors. But this is not a case where mental health can be considered neutral, and the trial court erroneously weighed the evidence when it
How
held
was the
otherwise.
mental health information on, I guess, both parties? How was that presented and exhibited to the hearing or brought to the trial court? I mean, was there testimony about it? Were medical records entered? How did all that come to the trial judge's attention?
That was included in the judicial diversion application packet. There was an expert report by Dr. Thomas Schacht who recognized that Mr. Albanese had severe autistic tendencies and that the victim, the child, had autism. There's also an offer of proof by the attorneys during the sentencing hearing that the victim's mother had autism, which also caused some issues. The trial court accepted all the judicial diversion application and its exhibits as evidence during the sentencing hearing, so that was given evidentiary weight. And there was no contrary expert evidence, and the expert mental health evidence in this case is why this case resolved in the way that it did, because the state acknowledged that it couldn't prove the sexual gratification element that would have been necessary for the sexual offense originally charged. One thing that Dr. Schott specifically said in his report that kind of drives a lot of this is that Mr. Albanese's autistic traits include a tendency to take things literally without understanding social nuances. So it's this general understanding of wrongfulness and sexual gratification. That was really the hook here. The trial court stated that it just didn't believe the uncontroverted expert evidence despite this agreement by the parties, and its determinations on this point was contrary to the record. As to specific deterrence, the trial court determined that the specific deterrence factor weighed against diversion, but given that Mr. Albanese had no other criminal history and the undisputed expert evidence showed not only that he had these autistic traits, but also we had a sexual offender report done of him that determined that he was a below normal risk to sexually offend and a low risk to behaviorally act out. And there was no contrary evidence on the record, and the trial court dismissed it out of hand and abused its discretion because there is no indication here that Mr. Albanese would offend again and need that specific deterrence factor.
Are you saying the trial court did not weigh and consider that psychosexual examination?
He raised it very briefly and just said that I don't believe that stuff. He made his own he made assumptions based on his own view of the case, really based on his general deterrence that I discussed earlier. He let his personal opinion to override all the evidence and was overly focused on those issues. In particular, the trial court relied on its past experience as an adversarial prosecutor and indicated that it didn't want to somehow condone sexual abuse through granting diversion, which of course is not the purpose of that statute. And I ask the court to vacate the sentence below and impose judicial diversion for Mr. Albanese. Thank you.
That's good.
Good morning, Your Honors. May it please the court, Johnny Saraceno on behalf of the state. In 2023, the defendant in this case, Mario Albanese, was charged with aggravated sexual battery. He later pled guilty to 3 counts of reckless aggravated assault. Per the plea agreement, the parties settled on a 9-year sentence, and the only issue at the sentencing hearing and now on appeal is the question of whether to grant or deny judicial diversion. At the sentencing hearing, not at the plea, but at the sentencing hearing, defendant's counsel presented some facts which the state did respond to afterwards and said that's an accurate reflection of the facts. And here's what it presented. When defendant's daughter was 2 years old, at her request, defendant touched her vaginal area in order to help her to go sleep. When she was approximately 8 years old, she reported to her mother, defendant's partner at that time. Defendant was interviewed by law enforcement. He readily admitted that this is what occurred and that's what he did.
Is there ever any, this is a little bit of an aside, but any conversation about how a 2-year-old could accurately remember that? That just kind of struck me as odd in this case.
Sure, I think there was some discussion of that in the psychosexual report. However, beyond sort of that discussion, sort of expressing a similar concern to some degree, we don't really have anything beyond that. However, I'll point out again, as the defendant readily admitted to in his recitation of the facts, is he admitted this both to law enforcement, to the victim's mother, and his letter of remorse seems to suggest, and his allocution seems to suggest that he did exactly this. There's been no denial of that aspect of this case. Finally, the defendant represented that defendant said it was not for sexual gratification. Turning to the court's analysis here, it discussed each of the Parker and electroplating factors. Again, the only issue here was diversion, and it communicated the weight it gave each factor. Because it discussed the factors, all of them, and gave each one a specific weight, this court's review of its decision denying diversion is for abuse of discretion with the presumption of reasonableness. To begin addressing it sort of more specifically, the court found that 4 factors weighed in favor of judicial diversion: the circumstances of the offense, general deterrence, specific deterrence, and the public's interest. And I'll also talk about the mental health and physical health factor as well. Regarding the circumstances of the offense, the court indicated or stated, opined that an adult knows better than to rub a child's private area so that she can sleep. The court also noted that it had been a traumatic occurrence as the victim remembered it 6 years later. Again, this occurred when she was 2. She reported it when she was 8 years old. And the court emphasized that the defendant admitted to committing the act, which helps verify the victim's account. It's additionally pertinent, I think, here that the defendant abused a 2-year-old victim with the excuse that she asked him to touch her. I don't know how to explain this any other way than to describe this as victim blaming in its strongest form. He's also said that he didn't act for purposes of gratification, sexual gratification, but the court looked at the facts as agreed upon by the defendant as well as the underlying charge, which it was allowed to do, and said, I reject that contention. The record supports the trial court's finding on this factor. The psychosexual report substantiates that the victim reported the incident years later, which supports the finding that it was traumatic. The stipulated facts, I think, very reasonably suggest that the defendant did act for purposes of sexual gratification, and the underlying charge, again, supports that fact. And the record supports the fact that the victim has blamed the victim or excused his behavior as being a mere lapse in judgment.
What about the fact that the trial court relied on its experience as a prosecutor of those types of cases rather than necessarily the evidence in front of him in weighing that deterrence factor? That seems a little inappropriate.
Your Honor, when evaluating general deterrence, the court's, I think, underlying point, it said, was to send a message to others not to commit these kinds of crimes. It did touch on its experience both as a prosecutor and as a trial judge, and sort of generally stated the proposition that it is generally known that these are a problem within society. And it did, again, ground that to some degree in its experience, professional training and experience. However, I did cite the Travis case, which I think has a relatively straightforward proposition. It's not without qualification, but the proposition is simply that it's almost inevitably a judge's personal and professional experience is almost, this is a quote, almost inevitably a part of a judicial determination. Close quote. Again, that's not without qualification, Your Honor. So I recognize the thrust of your question, but I don't think it did anything beyond what it should have, or certainly did not abuse its discretion in recognizing that it's generally understood and that we generally want to deter this sort of behavior. Generally understood that it's a problem and we want to prevent it in society. And so I think, quite frankly, that factor is certainly not, its analysis of that factor is not an error, and it's certainly not an abuse of discretion. Turning back, if I may, briefly to the mental and physical health here, the court said that defendant's mental and physical health was a neutral factor in its calculus, and my friend on the other side here has taken issue with that. The facts in the psychosexual analysis do discuss some of the defendant's autistic traits, but the court acknowledged this. It didn't hide or pretend that they didn't exist. What it said is that the evidence cut in both directions. The concern with this particular factor, which I'm not sure has been clearly discussed so far, is the question of, like, can you comply with judicial diversion or the requirements of probation? Would your mental health prevent you from doing so? I think it's been argued that mental health should weigh in favor of judicial diversion, but the real question is whether it would prevent. What the court said is there are mental health concerns here, and some physical health concerns, but the defendant has held down a job and been able to provide. In other words, mental health seems to suggest that it might cut against judicial diversion, but he's been able to hold down a job. And I cited the Sheets case for the proposition that if there's nothing that indicates a defendant can't comply with the conditions of probation, then the court may weigh that factor neutrally. That's exactly what it did here. It reasonably addressed the fact that there are some facts that cut in both directions. Certainly not an error, certainly not an abuse of discretion. Turning to specific deterrence here, if I may, I think this factor is quite significant. And the record supports the trial court's finding on specific deterrence that it weighed against judicial diversion. Again, I've said some of this before, but I'll repeat it. The defendant only admitted to the incident years after it occurred and upon the accusations of his 8-year-old daughter. That's very concerning. And again, the defendant has continued to deny that he touched his daughter for purposes of sexual gratification, continually and repeatedly attributing his abuse to either the victim's request or some sort of lapse in judgment. whether intentional or just a lapse in judgment, this is extraordinarily concerning behavior, certainly something we want to deter in the defendant. And this is not something I mentioned in my brief, but I'll mention it here now. And I want to be careful making arguments from silence here, Your Honors. But the victim's mother, the defendant's partner at the time, wrote a letter in support of judicial diversion. And what that letter said is that the defendant wouldn't pose a safety risk to her children because he would be on supervised probation and because, quote, defendant will continue to not be allowed to be around our children, period, close quote. What is noticeably absent from that statement is any indication that the defendant is safe around children or that the defendant would be safe around his own children. What the mother of the victim said is, my children will be safe because the defendant will not be anywhere nearby. I think these facts weigh in favor heavily of specific deterrence in the court's finding on that fact or on that factor. Regarding public interest, the court addressed this factor, and my friend on the other side has said, you know, it sort of talked about general deterrence here too. Well, of course it did. There's some degree of overlap between the judicial diversion factors, and it makes sense when you're talking about general deterrence, you're talking about the public, and when you talk about public interest, you're talking about the public. The court expressed concerns about public safety and general deterrence here regarding the public interest factor. It said, regarding the defendant's interest, it said this weighs in favor of the defendant, but ultimately the public's interest weighs against providing judicial diversion. And so I think very reasonably the court found that this factor weighed against judicial diversion. There's been some mention here that the state made a comment regarding what it could have or would have been able to prove at trial. There was an offhand comment there that said, yeah, this would have been, some of this, particularly the mens rea, would have been challenging to prove at trial. But we're not here talking about sufficiency, Your Honors. We're here talking about the judicial diversion factors.
But if the state conceded that they couldn't prove that element, which is why they entered a plea, isn't that some relevant evidence as to some of the factors that the court considered?
It could be, Your Honor. However, I want to be very clear here, and I think my friend on the other side has sort of equivocated on this sometimes in the briefing process. The court was clear, or the offhand comment by the prosecutor said it was going to be challenging or difficult. It didn't say it couldn't, or it didn't say impossible. And quite frankly, if we're going, if we're talking about the facts of the case, even the defendant's own recitation of the facts doesn't allege that the defendant didn't act for sexual gratification. It says that he claimed he didn't act for sexual gratification. And the remaining facts, the explanation of the incident is, quite frankly, I think a bit incredible, that the 2-year-old child asked a grown adult to touch him, and now he's saying that, no, I didn't do this for purposes of sexual gratification. I think looking at the facts, I think, quite frankly, I think they help establish that the defendant acted for purposes of sexual gratification. There's also been some discussion here, Your Honors, about 4035 to 10. The only issue here on appeal is judicial diversion and probation. These other issues discussed by my friend here are relevant to sentencing length, but that was agreed upon and accepted by the parties and the court. The statement that the allegation that the court said, I don't believe that stuff, and the psychosexual report, that's not what I gathered from the record. Again, the court talked at length, some length at least, about the mental and physical health, and it seemed to credit some of the mental health concerns expressed by the defendant and expressed in the psychosexual report. So this notion that it just simply denied it, I don't think I see that in the record. Turning to the allocution issue, if I may, and just to give, again, just to clarify some of the facts here, what happened was the court heard the arguments of the parties regarding judicial diversion, and it said, I'd like to think about this. I'm going to go back to my chambers and look everything over one more time before I come back. And I believe defendant's counsel said that, Your Honor, the defendant would like to allocute, and the court acknowledged that desire and seemed to indicate that it would allow it. After the recess, the court apparently forgot to let the defendant allocute at that point and went straight into its diversion analysis. I think per your question, Your Honor, you asked whether the defendant raised any concern, defendant's counsel raised any concern at that point or expressed a desire to allocute at that point. It did, counsel did not. Counsel allowed the court to go through the judicial diversion analysis and then reminded the court after it drew its initial conclusion that the defendant would like to allocute. At that point, the court did not place defendant under oath, subject defendant to cross-examination, or otherwise limit his right to speak freely and without interruption. In fact, the court encouraged the defendant to speak in the manner most comfortable to him, whether reading from a prompt or speaking spontaneously. So it didn't impede its right in that regard. And the court did reconsider the sentence once the allocution was given and the issue raised. It specifically discussed the circumstances of the defense, although briefly, I'll admit, and the mental health issues. So it discussed, or at least mentioned, mental health a second time. The court indicated at that point that it had read the letters attached to the defendant's memorandum, which defendant admitted and said was functionally the same as the allocution statement. The court stated that it read everything before it and considered it as evidence, including the allocution. So it's really unsurprising, I think, though it did give additional discussion. It said that very specifically that, I've weighed the factors. Diversion is a higher bar to reach, and the defendant has not reached that higher bar. So it did explain on some level that just as it weighed the factors, they just simply didn't reach the higher bar of judicial diversion. So its reanalysis was expeditiously made, but it did reconsider the sentence and ultimately decided to deny judicial diversion. Unless there are any other questions about anything I've discussed here, we ask that you affirm the sentence here and deny relief.
Hello. I'd like to start with the overall issue here. And the state here has reiterated some of the errors that the trial court committed below in really minimizing the mental health evidence in this case. At the sentencing hearing, the prosecutor, Joni Stewart, stated the mental health component was substantial, and it was the reason ultimately the experts were involved, and it was the reason ultimately that we thought it is in the best interest to resolve this case in this manner. That's on pages 10 and 11 of the transcript of evidence, the second volume. Your Honor, the mental health evidence here is serious, and it plays into every single role of this. It plays into the state's argument early on that an adult knows better, that it's significant that this child brought these allegations years later. But in this case, there was a delayed allegation against Mr. Albanese. As soon as he was confronted with the issue, he admitted that what he did and what he did was wrong. But he said again and again this was not for sexual gratification. This was an autistic father, an autistic mother, an autistic toddler that couldn't sleep. This is not a run-of-the-mill case. This is not a healthy adult who should know better, like the trial court stated and like counsel has stated here today. The trial court also repeatedly referred back to its professional experience as a prosecutor, and my opposing counsel referenced the Travis case. In Travis, the judge relied on something that it learned at a CLE conference, a neutral judicial education conference. That is completely different from the prosecutor here, who specifically said, I was a child sexual abuse prosecutor, and I'm worried about these crimes. But here, the state agreed that we needed to dismiss the sexual offense count, and the trial court granted that. And yet, the trial court continued to refer back to that dismissed count, as opposing counsel has done today. And this is troubling on several grounds, including what I referenced in my brief as the separation of powers issue. The sexual offense was dismissed, And because the parties agreed that we couldn't prove the sexual gratification element and decided aggravated assault made more sense here. And yet, even though the trial court agreed and accepted that plea agreement, it referred back to the sexual
Well, a trial
offense.
court can consider original charges even when they're dismissed as a result of a plea negotiation. Are you saying that can't happen?
They can, but in this case, the parties agreed that the mental health evidence couldn't be proven. And there wasn't evidence put on the record that supported sexual gratification. It supported the opposite, that
Was
he
that
did
not
not.
just a factor for the judge to weigh and consider, though? I mean, the trial judge isn't bound by what either party, is arguing.
He's not bound, but he did accept and dismiss the sexual offense charged here. And
Well, anytime a trial judge accepts a plea, they're accepting the dismissal of charges, but they can still consider what the original charges were, even on diversion. Do you disagree with that?
not as a general principle, but in this case, the trial court really minimized the mental health evidence to focus on sexual offenses because of his prosecutorial experience and other things. And the general deterrence and specific deterrence that he brought up was an abuse of discretion in this case. And, here, he was not convicted of a sexual offense. He was convicted of aggravated assault, causing extreme emotional distress.
Is that a statutory term? Extreme emotional distress?
Extreme emotional distress is a way to prove serious bodily injury. So that's how we slot into felony aggravated
I
assault.
mean, there's a statutory definition for serious bodily injury. Does that include emotional distress?
It does, Your Honor, and
It may be newer, and I'm just not familiar with it.
it's cited, I think, in a footnote in my briefing. But there have been cases before this court where
Cases, but it's not statutory.
right, it's a
'Cause it talks about impairment of mental faculty. Definition of serious bodily injury in the code talks about impairment of mental faculty, substantial impairment, I think it says.
Right, this is
So
based
you're
on
saying-
case law,
And there's case law that interprets that to also include.
that extreme emotional distress can constitute serious bodily injury. For these reasons and those cited in my writing, in my written filings, we ask that you vacate the sentence below and sentence Mr. Albanese to judicial diversion. Thank you.
Thank you, Gwen. Thank you, counsel. Appreciate it. We'll take this case with us and get an opinion out shortly. All right, call the next